The Texas Code of Criminal Procedure establishes that being found guilty of certain offenses may require a person to have to register as a sex offender. First, the Code of Criminal Procedure defines several relevant terms. According to the Code of Criminal Procedure, released means discharged, paroled, placed in a non-secure community program for juvenile offenders, or placed on juvenile probation, community supervision, or mandatory supervision. Next, according to the Code of Criminal Procedure, reportable conviction or adjudication means an offense, regardless of whether or not an appeal is pending, that may require registration as a sex offender, including a conviction, which means being found guilty, and receiving a sentence of jail, prison, or probation, or delinquency finding, which is being found guilty under the juvenile system, or receiving deferred adjudication from a judge, which is receiving a form of probation for an offense without having a formal conviction on your record. A reportable conviction or adjudication may be for continuous sexual abuse of young child or children, indecency with a child, sexual assault, aggravated sexual assault, prohibited sexual conduct, compelling prostitution, sexual performance by child, possession or promotion of child pornography, prostitution if enhanced to a felony of the second degree, aggravated kidnapping with intent to violate or abuse sexually, burglary with intent to commit a sexually oriented felony, unlawful restraint or kidnapping if the intended victim was younger than 17, and the second violation of indecent exposure, unless the second sentence is deferred adjudication. A person may also be required to register as a sex offender in the state of Texas for an attempt, conspiracy, or solicitation of any of the previously listed offenses or a violation of the laws of another state, federal law, law of a foreign country, or military law substantially similar to the previously listed offenses, or the second violation of indecent exposure under the laws of another state, federal law, law of a foreign country, or military law, unless the second sentence is deferred adjudication. A reportable conviction or adjudication may also be for online solicitation of a minor, or finally, trafficking of persons with intent of forced sexual conduct. Next, sexually violent offenses are defined as offenses committed by a person older than 17, including continuous sexual abuse of young child or children, indecency with a child, sexual assault, aggravated sexual assault, sexual performance by child, aggravated kidnapping with intent to violate or abuse sexually, burglary with intent to commit a sexually oriented felony, or a violation of the laws of another state, federal law, law of a foreign country, or military law substantially similar to these listed offenses. Next, the Texas Department of Public Safety shall provide forms for registering sex offenders to the Texas Department of Criminal Justice, which operates prisons and parole, the Texas Juvenile Justice Department, which is still listed in the Code of Criminal Procedure by its former names, the Texas Youth Commission and the Texas Juvenile Probation Commission, and each local law enforcement, campus security, county jail, and court authority. According to the Code of Criminal Procedure, a convicted sex offender commits an offense when they fail to register when required. He or she commits a state jail felony if they fail to register when they are required to register for 10 years. A felony of the third degree if they fail to register when they are required to register annually for life. And a felony of the second degree when they are required to register every 90 days for life. Finally, a person commits an offense if the person, after commitment as a sexually violent predator, but before release from all requirements of the civil commitment process, fails to comply with any requirement of this chapter. So this statute makes it a criminal offense for a person who is a sexually violent predator who has been civilly committed to a residential facility and they fail to comply with any requirements of this chapter. All of these types of offenses are felonies of the second degree.